Hello, IP friends. Welcome to another episode of IP series with Rita. Yep. So, if you haven't listened to episode 92, featuring the Zara of the Dawn case, where the U.S. Copyright Office had awarded a partial copyright registration. For the work itself, I discussed extensively what legal framework we can opt for, what is the impact of the decision to AI creatives and digital artists, because I had joined a Twitter space where it was, digital artists out there, and they were just wondering. And now the US has published a new regulation regarding the copyrightability of AI created work. So if you want to check that out, just do a Google search about it. But that it goes to show you how proactive the US, the UK, the EU are regarding this conversation. I also saw that the UK has also appointed the 13th IP minister regarding AI and intellectual property rights. So it's going to be an interesting area. So I'm just going to point out 5 guidance for intended digital artists that was published by Michael Eshagian. I don't think I pronounced his surname well, but his name is Michael anyways. And it says any digital artists that want to protect their generative work should disclose and provide the explanation of the human contribution, which was something I had alluded to, stating that Christina Kashtanova should have disclosed the contributions of each party instead of stating that, I created this and later on went to go and do a publication stating XYZ. Then it said that you should not list AI or the company providing the AI as a co-author, which is kind of different from what India provided. It says any AI generated content that is more than minimal must be explicitly excluded. The application that have already resulted in registration, the applicant should submit a supplementary registration to correct the error, or else they risk the cancellation of the registration, which was what happened to the Zara of the Dawn case. They cancelled and reissued just for the part that had human intervention, which is the author Christina. And finally, pending applications should be reviewed for adherence to this requirement, and if necessary, the applicant should contact the Copyright Office, Public Information Office, and report the omission. So, like I said, just do a Google search on the new regulation regarding copyrightability of AI created work. So that's like the updates I have before we delve into our conversation for today. So welcome once again to IP Series with Rita. My name is Rita Anrichinda. I am a Port Harcourt based intellectual property lawyer. I'm also an arbitrator as well, but basically this podcast focuses on recent cases and developments regarding IP mechanisms such as copyright, trademark, patent, industrial design, trade secret, plant variety, and geographical indication. These are the major forms of IP. I think 2 in the list are not common, but I just analyze cases, giving my own personal view. I also do a Twitter mini blog version. I also have a newsletter which you can also subscribe to. So just search for IP series on Google and subscribe to all my content, or just look out for my post where I will insert the link. And for my returning listeners, we're getting closer to 100, my 100th episode, and I would like to appreciate everyone who has stuck with me throughout this journey. It's not been easy, but your girl will always come back. If I miss a month, please forgive me for that, because I noticed I didn't publish any podcast in February, but I also did so that other mini publications on other platforms. But thank you guys for holding the fort with me and staying with me and also encouraging me. I see your comments, your likes, your retweets, your reviews, my DM, my email. Not easy, guys, but thank you. I love you guys. But let's get into our conversation for today. So it's few days again to the Nigerian elections. This time it's the governorship elections coming up on the 18th. Yeah, on the 18th. And the presidential election was filled with a lot of uncertainty. It wasn't properly done. For me, I'm going to rate it a 30 over 100 because our mandate, I do believe our mandate was stolen because the voice of the people, I mean, people usually don't come out for elections because they're like, my vote will not count. But this time, people came out and voted. There was a lot of videos and publications as to election manipulation, results being manipulated, and now Labour Party has filed a suit. There's a petition ongoing, waiting for INEC to obey court orders. But then, INEC has, like most Nigerian agency, been stubborn in obeying court order. For instance, now our election results, the presidential election result, was announced at 4:10 a.m. when most people were asleep. I mean, someone posted and I was like, is INEC not supposed to be working 24/7? I mean, this is the period. But why do that? Kind of feels like I was going to say something, but I'm just going to hold myself. But yeah, let's focus on today. And I hope whoever's listening to me today vote wisely in their various states. I know who I'm going to vote for. I'm not going to mention this. It doesn't seem like my post is a political one endorsing someone. But yeah, let's vote for the right people. We need to get it right within the next 4 years and make sure that Nigeria is where it needs to be. So this IP story for today features the electoral body known as the independent sorry guys, so Independent National Electoral Commission and 5 other persons were sued by a company called Bedding Holdings Ltd. And now these people are like besties. They've been in business for a very long time. So let's go through the list of things that they are being. So Bedding Holdings Ltd or BHL is suing INEC and 5 other persons in relation to the process and application, collection of various biometric information, the transparent collapsible ballot boxes, permanent voter card, data capturing machine, electronic card readers, proof of address system scheme, etc. Now, my point and where I'm driving at now is that even INEC needs IP materials. Like everything, like I've stated, everything around you has IP elements, from the name, inventions, everything you're doing has intellectual property. Now, when a long-time special contractor gets or has their intellectual property used without their consent, what do you think is the best mode of enforcement for such a special contractor? Bedding, that's BHL, is a company that specializes in the general fabrication and manufacturing of steel metal products such as the aforementioned. That's the works I listed as the transparent ballot boxes, the collapsible transparent boxes, and they have patent and industrial design rights for the fabrication of the transparent ballot boxes, which was registered in 1998 and got another one for sometime in November 2006 for its invention of the electronic collapsible transparent ballot boxes, as well as patent right for the proof of address system scheme, while the electronic card readers and PVC enjoy another set of patents. So what does this tell you? That anyone that wants to go into business with any agency needs to, first of all, consider protecting themselves. Document your IP, register it, because you can never tell. There's nothing like a gentleman's handshake. No. Try go get your IP protected. Now, patent is one of those IP mechanisms that aids inventors, providing a simple fix that can make a difference in the world that no one has ever done. So that basic requirement of being new has to be complied. And also in filing your application, you need to be very transparent and detailed when drafting your claim. It's also very important that you take your research, designing, development seriously so that the improvement you seek would qualify or meet the requirements of being new, novel, and not obviously skilled person, and also not contrary to public law and morality. Now, it turns out that BHL has been an INEC specialized contractor since 1987. Wait, I need to do this math. Hold on. So the math I did was deduct 2023 as 2023 minus 1987, and that gave me 36 years. However, let's put this below 30. That's how long their relationship lasted, because I don't know if they are still, I do not know for a fact if they are still the contractors that INEC had to use for because we didn't have any collapsible box in my polling unit. No, we didn't. But we did have, what's that thing called now? Can't remember, but yeah, let's move on. So INEC has been using BHL since the time they were called the National Electoral Commission of Nigeria. Now, turns out that sometime in 2003 of January, BHL signed a licensing agreement with INEC and the INEC chairman then, which is Atahiru Jega, for the use of the transparent ballot boxes till 29th of March 2003. So they needed 500,000 units of the transparent ballot boxes. That was the licensing agreement. And licensing agreement, like I know, has to be, so you have the exclusive licensing agreement, which has to be in writing between both parties and describe what the parties are going to license the agreement for, what is being licensed, how long that will be used, how much will be paid, etc., etc. So imagine when your long-time partner breaches your contract and decide to sub-license to a third party, not just one but multiple. So INEC went behind BHL's back they went into a contractual relationship with High Electrical Appliances Corporation Limited, Xenox Tech Limited, Advantage International Tech Incorporation for the production. So Advantage International Tech Incorporation for the production, procurement, supply, acquisition, importation, purchase, sale of the direct data capturing machine, laptops, the collection and compilation and production of the voters register for the 2011 general election. So I would want to believe that between 2003 to 2011 they were still working with INEC until INEC decided to breach their contract. But then you need to know that once you fix a term of duration and that has elapsed, you need to go back and renew your license. So probably INEC did not renew their license with BHL. At least I didn't see that in any of the documents I had to read. But then they went ahead to, sub-license or give another contract. But is that a bad thing? Is that a bad thing? That I'm not into any business chicken, but I'm going to... I mean, it's a bit tricky. Don't you guys think? I think so, because probably they had to show samples to these companies to, reproduce. So it stated here that they had to import, purchase, and sell the direct data capturing machine, laptops, and other things to be used for the 2011 general election or any other elections. But then they did that without pre-informing BHL that their patents, their invention was going to be used for XYZ. And then Bedding sued, and then they got a court judgment that was delivered by Justice Adamu Bello, which stated that INEC was barred from using the boxes for subsequent elections without the consent, permission, and authorization of BHL. But most Nigerian agencies, INEC disobeyed court order. What is wrong with you guys in Nigeria? Why do you keep... Okay, I'm calm. I am calm, guys. I am calm. But then, INEC went ahead to use the ballot boxes for their 2011 general elections and 2012 Edo State governorship election. And now we have another governorship election coming up. So I think I might just, okay guys, I might just do a Google search now to confirm who the present contractor is. Because I don't know, if someone keeps effing you up like this, like through the back, would you want to still remain in that relationship with the person, even if you have been? So it's kind of like, I don't want to relate it to relationship. It's kind of, I don't know, guys. I don't know. I beg. But for someone who has been a special contractor that long, what did you do differently that made INEC switch up on you? Not blaming you guys, but then I do respect inventors and creators, and businesses that go as far as wanting to protect their creation and intellectual property. So first off, we're going to start with industrial design, just to take you through what I feel manufacturers or business owners or people who are in the who would want to bid in future for INEC to give them their briefs, because one of the laws that BHL had referred to was section 42 sub 1 paragraph 2 of the Public Procurement Act 2007, and also section 6 sub 1 of the Patent and Design Act. So like I stated, I'm going to start with what businesses should know when it comes to the two major forms of IP that I'm discussing today, which is industrial design and patent. So industrial design protects, under section 12, it protects the combination of lines or colors, or both lines and colors, and any three-dimensional form, whether or not it is associated with colors. Now section 14 sub 1 and 2 provides that any true creation or creator shall be named. So it's mandatory that you name the person that created that work, which in this case would be BHL. And also they are vested as the first person who, and also vested, that's creatorship or ownership is vested in the first person who files the industrial design and can validly claim foreign priority. In this case, who would be Bedding, that's BHL. So in essence, like I think I've stated that in my previous episode, that under the Nigerian IP system we apply the first to file principle. So who file first, then go name as creator, and then go talk say, oh, now this person gets the invention or the industrial design, which protects the visual appearances, which combines lines and colors, etc. Now, did you know that as an industrial design applicant, you can ask the registry to keep your design a secret? I guess why they now paired patent and design together, because for patent you also need to keep your no disclosure at all. So as a design applicant, industrial design applicant, you can ask the registry to keep your design a secret for at least 12 months from the date of your application, and that shall be enclosed in a sealed package and shall be opened by the registrar when the 12 months has elapsed. It can also be opened per the applicant's request. That is, before it has elapsed, before the 12 months has elapsed, you can also apply that it should be opened and then to be converted into an open application. So you can read section 18 sub 1 paragraph A, sub paragraph 1 to 3. Now in this case, BHL got their IP registration in 1999 and another one in 2006. So one thing that businesses need to consider, that they need to have good reputation for enforcing their intellectual property rights, so as to prevent anyone from taking advantage of them. And this is not a David and Goliath fight right now. You need to be proactive. You also need to have a good data protection policy to protect your business from cyber criminals and any espionage. You also need to restrict access to your intellectual property. You need to implement an incident response strategy and always perform a risk assessment to identify possible risks to your IP. Now, an overlap between registered industrial design and IP are subjects. So the subject matter will take into consideration first of all. So the subject matter in relation to the IP requirements for registration must be checked. So for design rights, it must be new. and which is kind of similar to a patent where your patent has to also be new. You also need to look at the fact that your design must be a combination of lines, colors, and protect your visual appearance, etc. Now, both IP mechanism can be used to protect new works, but they require thorough analysis, the technical analysis of the technical aspects and non-technical features of the aesthetics and appearance of the product. That is for design rights. Now let's delve into the patent. So I already stated that patent protects new works. However, let's look at the patent infringement aspect where BHL kept, suing INEC repeatedly, because INEC wasn't sued just once. I think they were sued multiple times. You get it? So let's talk patent infringement now. Although, okay, let me just do like a brief analysis of what industrial design infringement will entail. So section 25 talks about the infringement of right either for patent or designer. It says the right of a patentee or design owner are infringed if another person without the licensee of the patentee or the design owner tries to explore any of the acts granted to a patent owner or a design right owner under section 6 for patent and section 9. So hold on, I'm trying to get to it for you guys. So 6 and 9. But let me just focus on section 6, which talks about the rights of a patent owner. So, right of a patent owner. When a patent is granted in respect to a product, the act of making, importing, selling, or using the product or stocking it for the purpose of sale or use. So remember that one of the reasons why why BHL sued INEC was that they had sub-licensed the act of making, importing, selling. Let's see now. The act of making, selling, importing, acquisition, purchase, supply, procurement of what BHL was doing. And when a patent is granted in respect of a process, the act of applying that process or doing in respect of a product obtained directly by means of the process or any of this, the scope of protection conferred by a patent shall be determined by the terms of the claim, and the description and the plans and drawing included in the patent shall be used to interpret the claims. And the right shall extend only to acts done for industrial or commercial purposes, and shall not extend to acts done in respect of a product covered by the patent after the product has been lawfully sold in Nigeria, except insofar as the patent makes provision for a special application of the product, etc. Now let's look at rights of a industrial design. Hold on. Now, rights of industrial design, you can read section 19, which states registration of industrial design confers upon the registered owner the right to preclude any other person from doing any of the following as reproducing the design. So the design will be for the collapsible transparent boxes, the PVCs, the data capturing machine, etc., importing, selling, or utilizing for commercial purpose. I know that when someone commercializes another person's intellectual property, that's alleged infringement because you're making money from it. Whereas non-commercial purposes, you're using it for private use, you're doing a research about it, you're using it not with the goal or aim of making profit from it. Another right that a design right owner has is that holding such a product for purpose of selling or utilizing it for commercial purposes. So the section 19 makes emphasis on commercial purposes. So then sub 2 provides that the reproduction of a registered design is not lawful for the purposes mentioned in subsection 1, merely because it differ in minor or inessential ways from the design, or because it concerns the type of product other than the type with which the design is concerned, which is why BHL sued INEC. It's not whether the difference that I would get from hair electronics or what's the other company now, Xenox, there's a minor difference. It's not really obvious, or the product is not the same. It's so far as it's for commercial purpose, your act is not lawful. The right conferred by this section, which is section 19, shall only extend to acts done for commercial or industrial purposes and shall not extend to acts done in respect of a product incorporating a registered industrial design after the product has been lawfully sold in Nigeria. So let's move down to what a patent infringement really entails, and I will then talk about other. I think I already talked about. I didn't talk. Okay, that I mentioned it briefly. Yes, I did. Section 25, which talks about infringement. But yeah, let's just move on and we'll continue from there. So I was just reading through my write-up and I saw that I didn't give like an in-depth explanation as to licensing with for say a patent or a design right. So section 23 talks about contractual licenses. So it says a patentee or design owner may by a written contract. I know I stated that an exclusive right license has to be written. It has to be signed by parties to grant a license to any person to exploit the relevant invention or design. And in the absence of any provision contrary in the contract, the licensee shall be entitled to do at anywhere in Nigeria in relation to the patent or design any act mentioned in section 6, which is the act which talks about making, importing, selling, or using a product. Section 9 talks about nullity of a patent, basically. Section 10 also talks about licensing of rights, but we're talking about contractual licenses right now. So let's just finish that and go back to so it says when a license is granted under subsection 1, the license shall be registered. So if that license between BHL and INEC should have been registered, but then for business owners or IP enthusiasts or lawyers who are listening to me, if you draft a license an IP license, basically make sure that you register it, whether it's a patent or design or trademark. So the license shall be registered and shall be of no effect against third parties until registration is effected and the prescribed fee is paid. The registration shall be cancelled at the request of the licensor if the registrar is satisfied that the license has been terminated. Now, any clause in a contract for a license under subsection 1 is null and void insofar as it imposes on the licensee in the industrial or commercial field restriction which do not derive from the rights conferred by the relevant patent, provided that limitations concerning the scope, extent, territory, or duration of the exploitation of the patent or design, or the quality or quantity of the product in connection with the patent may be exploited. Obligation imposed on the licensee to abstain from all acts capable of prejudicing the validity of the patent or the validity of the registration of the design. In case of a patent, limitations justified by interest of the licensor in the technically efficient exploitation of the subject of the patent are not restricted. Now, in the absence of all of this, a license that is in writing, that's a written contract signed by both parties, will not prevent the licensor from granting further license. So the owner, BHL now, will not be prevented from granting further licenses to other people. So they are open to going into non-exclusive licenses. It will not prevent him from exploiting the relevant patent or design. The licensee now, which is INEC, shall not be assignable by the licensee. So the INEC should never have even assigned that right to Zeno and the rest of them. They shall also not grant further licenses. So it's not within your power as a licensee. You're coming to ask me for permission, then you want to give another person a sub permission from that. So it also states that where a written contract signed by parties provides for a licensee to grant further license, this section shall apply in relation to any such further license as it applies in relation to license granted under the said subsection. So INEC, I think one thing that I can take from this is that if you're going to go into a licensing agreement and you have intention of sub-licensing, I think you should put it forward so that it will be included in the agreement between the written agreement between you and that person, and if they don't agree, you don't indulge. Now, subsection 6 of 23 says that the minister, if he is satisfied that it is in the interest of Nigeria and his and its economic development to do so may by the other in the Federal Gazette provide that contracts under subsection 1, which is written contract signed by parties to grant a license to any person to exploit the relevant invention or design, shall, insofar as they involve the payment of royalties outside Nigeria, be invalid without approval of such authority. So this was within Nigeria. So I know there was issue as to royalty payment, etc., etc. But then I also mentioned section 10, which talks about licenses of right. Now it says, and this is with regards to patent, now it says, if a patentee, that is INEC now, applies in writing to the registrar for the words licenses of right to be registered in respect of, this is in relation to BHL. The registrar shall enter the words accordingly in the register and notify the entry. And where that entry is made, in respect of a patent, any person shall have the right to obtain a license to exploit the patent on such terms as failing agreement between parties and the person and the patentee shall be fixed by the court. This is when the court is going to actually interfere in a licensing agreement. The amount of the actual fee in respect of the patent shall be reduced by half. So you see there, the enforcement is always our issue in Nigeria, basically. A patentee may at any time apply to register for an entry that it should be cancelled, and if no license has been granted, and all the grantees agree, the registrar shall also cancel the entry, and the grantee of a license under this section shall not be entitled to assign the license or grant further licenses. So INEC has no right to sub-license any contract, or if you're getting a license for someone, you do not have the right to sub-license anything. Now, let's go back to our conversation regarding patent infringement. Now, sometime in 2014, the Federal High Court found INEC to be guilty of infringing the patent rights to a process belonging to BHL that covered the process of application of direct data capturing, machines for the compilation and collection of various biometrics information, and stated that they were covered by patent. I also came across a court's process dated sometime in 2020. That's like 3 years ago. Unscribed. I think when I talked about this on Twitter, I posted the link. Now, it turns out that INEC refused to obey the judgment and court order dated 5th June 2012, 28th January 2018, and the suit filed in Abuja. So the suit numbers are CS/816/2010 and Federal High FHC/Abuja/CS/82/11. Okay, yeah, same thing. And BHL was asking the court to declare that INEC and the chairman of INEC were guilty of Section 25, which I took my time to read out for you guys and talked about. Section 25 focuses on infringement of rights, be it design right or patent right. So they were relying on subsection 1 and subsection 2. I'm not going to read that again. You guys can Google it later on. Okay. He also talks about infringement of intellectual property right exercised by the rights accorded to a patent owner without BHL's consent. The patent owner in this case is BHL. Now, where they use his patented products and concepts during the by-elections of 2015 and 2019, based on Section 3, sub 1 through 3, Section 3B. Okay, that's sub 3B, sub paragraph 1 and 11, and also of the Patent Design Act, which provides that a patent application shall relate to inventions but may include a connection with that invention for a number of products, manufacturing processes for the products, or any number of applications of those products which the claim shall apply to any number of processes and the means of working these processes for the resulting products and also for the applications in these products. However, I was reading this section. I was reading the first schedule of part 2 in the Patent and Design Act. It talks about the use of patent for services of government agencies. So when a government agency decides that they want to use someone's patent, such as agencies like INEC, paragraph 15 provides that where a minister is defined as the minister of the Federation, and a state commissioner when the minister is satisfied that the use of a patent will be in the interest of the public. They may authorize any person, in this instance maybe INEC chairman, to purchase, exercise any patented invention for the service of a government agency, which, like I stated, federal or state ministry or department of government, e.g. statutory corporations which have been directly established by the law to perform its functions, a local authority or a voluntary agency, hospital. And paragraph 17 also states that the government agency or supplier shall be exempted from any liability of an infringement payment of royalty. So does this mean that INEC is excluded from paying royalties as a result of an infringement? I don't know. And then also, in that document, it was, how many pages? It was a lot too. I was like, see what this is I'm doing for you guys. I'm reading too much. But that's my job. I'll read and explain the best I can. But yeah, BHL, we're asking the courts in the application to ban INEC from using their patent, that INEC should give them back their patented product so that they can destroy it publicly. They also said that the quantum of the judgment sum must be fully paid or paid by installment with an accruable interest of 22%. I think that's a lot. Then 10% for post-judgment interest sum. And then they were asking for the sum of 300 billion. How much did the census people ask for again? Okay, they're asking for the sum of 300 billion naira as general, exemplary, aggravated damage for the unauthorized use, continuous breach, and further use of their transparent ballot boxes, electronic collapsible transparent ballot boxes, voting cubicles. Yeah, that's what I was trying to remember. Where you go and hide and dump it LOP or PDAPC, any party at all. Data capturing machines. Then paragraph 19 provides as well that the revision of a license or an assignment or agreement made before or after the commencement of the this PDA, that's not public display affection. No, I like that one, but this one I'm talking about better than Design Act. Between a patentee and any person other than the government or ministry shall have no effect as long as the provision restricts, regulates the use of patented invention. Oh girl, I don't even know, say, like, petty things. So I think INEC also takes advantage, or any agency that does their due diligence when they are sued, we always want to look for a gap in the law to rely on to do what they want to do. Now, did you know that there is a pending monetary judgment of 17,258,820,000 naira against INEC? And on the 26th of September 2018, a garnishee order 9C commenced against INEC. Now, what is a garnishee order? According to Ekimini Udim, he defined it as a judicial proceeding by the judgment creditor against the person in custody or possession of money belonging to the judgment, or a process of enforcing a money judgment by the seizure or attachment of the debts due or accruing to the judgment debtor, INEC. So the judgment debtor is INEC, the judgment creditor is B. Hold on, no. But yeah, by ordering a third party, CBN or the bank, to pay the money owed to the judgment creditor. Now the first stage is to get a garnishee order. So your lawyer will help you do that. Get another 9C through an ex parte application with an affidavit to BHL to obtain this line arose as a result of INEC refusing to pay the money that they owed them, and also the ongoing what will I say now? Disobedience of the court order. So the court, after discovering, so they'll pay by going to the court after discovering the bank that INEC has to receive funds, and by that order they will direct that the money be paid to the court or to BHL directly. Now the bank in this case is called the garnishee. BHL is known as the judgment creditor, while INEC is known as the judgment debtor. Have I made myself clear? Yeah, I think I've explained, done like a brief summary of what is expected of a judgment creditor when they're trying to get their money back from someone. So moving on, I'm going to be talking about the burden of proof in a patent infringement. First, the burden of proof is always on the claimant, which in this case is Bedding Holdings Ltd, BHL. You have to show and prove what elements of your IP has been infringed. You also need to show that there was some sort of lack of consent from the alleged infringer. You also need to reduce the burden if no new work was created from the IP in question. So there's a whole lot of responsibility required from a patent owner or an industrial design owner. So first, how do you then choose the right intellectual property mechanism? You need to identify the elements with commercial value. So just like how BHL was like, okay, these ballot boxes, the data capturing, etc., they all have commercial value. Let me go and patent and register the aesthetics of this works. You also need to opt for a multi-layer. You need to opt for a multi-layer scope of protection. What that basically means is that instead of relying on just one type of intellectual property to protect your business, you can have to just pick, okay, is it the name, trademark? Is it the invention, patent? Is it the aesthetics or visual appearance, industrial design? Is it the literary and artistic work, copyright? Is it the confidential information or that thing that gives my business an edge, trade secret? Figure out that with your intellectual property lawyer. And I think every business should have an IP department. No, I think it's very important, because you find out that with, I don't want to say developed countries, but then I just have to say it. You find out that businesses in the US and the UK, most of them have IP departments, or they have IP lawyers or law firms on their retainer that helps them in figuring out the best mode of protecting their IP. Always carry out a risk assessment to identify the risk to your intangible assets. Develop a good reputation for enforcing your intellectual property right. Next up is, it will be like my, what's it called now? Tips for inventors, manufacturers, such as BHL, what they need to do in terms of intellectual property. I mean, IP has commercial values, and if you do it right, you're going to get the best out of your invention. So first off on my list is, you need to define your relationship with a document. For instance, a specialized contractor like Bedding had to sign a licensing agreement with INEC. So that defines your relationship. Okay, I am the licensor, you are the licensee. Or I am producing XYZ or doing XYZ for you. Next up, you need to then endeavor to register your intellectual property with the intellectual property registry or offices within your jurisdiction. Make sure that before you apply, your IP meets the basic requirements, whether it's a new, novel, it's in a fixed or tangible format, it's confidential, and you've taken measures to protect your information, it's the visual appearance of your product or invention, or that invention is providing a technical solution in an area or problem that ends up giving you exclusive rights to prevent any unauthorized sale, making, use, stocking, importing, for the purpose of sale. It also which is usually determined by the terms of your claim, the description, which is included in your patent application or your design right application, whatever kind of IP you're opting for. According to Section 10 of the Nigerian Patent Act, a patentee seeking to obtain a license can apply in writing. I think I previously stated that. You apply in writing to that the registry should protect the work, and that anyone that wants to use this must obtain license from you. You also need to know that ideas cannot be patented, and neither do they enjoy any form of intellectual property protection. You need to also be proactive in enforcing your intellectual property right. You need to also invest in research and development from your pre-market and after post-market as well. Retain an IP lawyer, retain an IP law firm. I will keep saying that in any episode that I publish, because it's very important that brands understand that they can't do without us. And yeah, I think I am done with today's case. But basically, you know that patent protects inventions, while design right protects the aesthetic visual appearances of your business. And then, as we look forward to voting on Saturday, let's vote wisely this year. I was going to say vote for so and so, but I'm not going to tell you who to vote. But yeah, know that if someone infringes on your intellectual property, your patent or your design rights, the Federal High Court has the jurisdiction to hear your matter. Or you can opt to settle out of court by exploring alternative dispute resolution mechanisms or online dispute resolution mechanisms. I think the pandemic also showed us that you don't need to be in a physical place to, have your hearings. We saw a lot of guidelines and rules being provided for virtual hearings and stuff like that. But yeah, I hope with these few points of mine, I've been able to convince you as to what is expected of a business person, what you need to show and prove when your work has been infringed upon, and any other thing you think if I missed out anything or you have questions, but yeah, if you have plans of creating products that INEC can use so that we will get to experience that free and fair election. I think it's about time that we start voting electronically as well. Vote for who we want from the comfort of your home without any form of manipulation. But then again, like I say, whoever has the back end can do and undo. You get it? So yeah. And so we have come to the end of today's episode 93. Thank you once again for listening to me. I do appreciate. Don't forget to like, share, subscribe, favorite, just follow my content on any of the platforms you're currently listening to me. You can also follow my newsletter, my mini blog series on my personal page at Esmeralda ASQ. But yeah, you can find me on Twitter at IP Series 1, Instagram at IP Series _reader. So reader is spelled REEDAH. You can also send me an email to ipseriesInfo@gmail.com if there's something I wasn't clear about, or you need consultation or trainings on IP. I am your go-to girl and your blog. But yeah, thank you so much for following IP Series content. And if you're Nigerian, please vote wisely. Vote wisely. Mbok, Ejo, Biko, Nzamwe, Adebeg. Vote wisely come March 18, 2023. And yeah, see you in episode 94. Have a fantastic day, guys. Bye.